A sham! I'm getting mad at you! Judge William Alsup's voice thundered through the courtroom, his words slicing through the tense silence like a blade. The U.S. District Court for the Northern District of California had been a battleground all morning on March 2025, but this outburst marked the peak of an already heated hearing. The target of Alsup's fury was none other than Pam Bondi. Bondi had walked into the courtroom just moments earlier, her presence an unexpected jolt to the proceedings, and now she stood at the center of the storm, facing a judge who was not holding back. The case before Alsup was a high-stakes lawsuit filed by the American Federation of Government Employees and other unions, represented by their lawyer, Mr. Helland. They were challenging a wave of mass firings ordered by the Trump administration in early 2025. Thousands of federal workers, mostly probationary employees with less than a year of service, had been terminated across agencies like the Department of Defense, the National Park Service, and the Bureau of Land Management. The plaintiffs claimed the firings were illegal, arguing that the White House had directly instructed the Office of Personnel Management to carry out the terminations, bypassing federal laws that required a formal reduction in force process. The Trump administration, however, insisted the agencies acted on their own, a claim that had already drawn Alsup's ire earlier in the hearing. Before Bondi's arrival, the administration had sent Assistant U.S. Attorney John Carter to defend the case. Carter had stumbled through his arguments, claiming the White House only requested the firings, not ordered them, and that the agencies independently decided to let go of employees they deemed unnecessary. Alsup had seen through the flimsy defense immediately. He had berated Carter, his voice dripping with frustration, saying, "How could so many agencies on the same day decide to fire thousands of workers without a direct order? This is aberrant in the history of our government. I've been on this bench for decades, and I know when I'm being fed nonsense. You're wasting this court's time with these excuses." Carter had tried to deflect, suggesting the fired employees should seek redress through the Office of Special Counsel or the Merit Systems Protection Board. That only fueled Alsup's anger further. "This is a federal court, not a suggestion box," Alsup had snapped, slamming his gavel. "The White House doesn't get to sidestep accountability by passing the buck. I want someone from the administration who can answer for this, now." As if on cue, Pam Bondi had entered the courtroom, her arrival sending a ripple of surprise through the spectators. It was rare for an attorney general to personally appear in a district court hearing. Typically, such cases were handled by subordinates. But Bondi, confirmed as attorney general on February 4, 2025, and sworn in the following day, was not one to shy away from a fight. She had a reputation as a fierce litigator, honed during her time as Florida's Attorney General from 2011 to 2019, where she was the first woman in that role, and as one of Trump's defense attorneys during his 2020 impeachment trial. Her close ties to Trump, coupled with her legal acumen, made her a polarizing figure, and her decision to step into this courtroom signaled the administration's determination to defend the firings at the highest level. Bondi had barely introduced herself when Alsup unleashed his tirade. "How dare the White House instruct agencies to fire thousands of workers, probationary employees who are the lifeblood of our government, without legal authority?" he demanded, his voice rising with every word. "You can't just gut the federal workforce because the president wants to clean house. I've seen the evidence, and it's clear these firings were ordered, not requested. Explain yourself, or I'll hold the administration in contempt." The weight of Alsup's words hung in the air, a direct challenge to Bondi's authority and the administration she represented. Spectators held their breath, expecting the Attorney General to falter under the judge's blistering attack. Alsup was a veteran jurist, appointed by President Clinton in 1999, and known for his no-nonsense approach. He had a history of taking on powerful entities, from tech giants to government agencies, and he wasn't about to let the Trump administration off the hook. But Pam Bondi was not one to be intimidated. She stood tall, her expression calm and resolute, even as Alsup's accusations echoed through the courtroom. She had faced tough opponents before: prosecutors, defense attorneys, even hostile crowds during her tenure in Florida. And she wasn't about to let a judge's outburst derail her. Bondi had come prepared, armed with a deep understanding of the law and a fierce loyalty to Trump's agenda. She knew the stakes were high, not just for the administration, but for her own reputation as the nation's top law enforcement officer. "Your Honor," Bondi began, her voice steady and measured. "With all due respect, the administration's actions are fully within the law. The White House has the authority to set policy directives for federal agencies, and the OPM's role is to implement those directives. These firings were not a purge, but a necessary restructuring to ensure that agencies are staffed with employees who align with the president's mission to make America safe and efficient again." Alsup cut her off, his tone sharp and unyielding. "Don't give me that. The OPM has no statutory authority to order terminations, none. I've read the memos and they're clear. The White House told agencies to fire these workers. You can't just bypass federal laws like the RIF process, which requires notifications and protections for veterans. This is a blatant abuse of power." Bondi didn't flinch. She had expected resistance. Alsup's reputation preceded him, but she wasn't about to let his emotional outburst dictate the course of the hearing. She leaned into her argument, her voice firm but controlled. "Your Honor, the plaintiffs are mischaracterizing the OPM's actions. The January 20th memo and February 14th email were guidance, not orders. Agencies retain discretion to evaluate their workforce needs. Moreover, probationary employees, by definition, serve at the pleasure of their agencies during their trial period. The Civil Service Reform Act of 1978 grants agencies broad authority to terminate probationary employees without the full RIF process, as long as due process is followed. We've complied with the law." Alsup scoffed, his frustration boiling over. "Guidance? You expect me to believe that dozens of agencies independently decided to fire thousands of workers on the same day? That's preposterous. And don't lecture me on the law. I've been on this bench longer than you've been a lawyer." The judge's words were a direct jab at Bondi's credibility, a challenge meant to put her in her place. But Bondi wasn't fazed. She had spent years in courtrooms, facing down opponents who underestimated her, and she knew how to handle a judge who let his emotions get the better of him. She took a deep breath, her mind racing through her legal arsenal, and responded with a precision that caught everyone off guard. "Your Honor," Bondi said, her tone calm but laced with steel, "I've been a prosecutor and Florida's Attorney General for nearly a decade, and I've argued cases before judges far more intimidating than this. I respect your experience, but the law is on our side. The Supreme Court has consistently upheld the executive branch's authority to manage its workforce, as seen in Myers v. United States in 1926 and Humphrey's Executor v. United States in 1935. The President's Article 2 powers include directing agencies to align with his policy goals. If you disagree, issue your ruling and we'll take it to the Ninth Circuit, or the Supreme Court if necessary." Bondi's response was a masterstroke, a blend of legal reasoning and subtle defiance that shifted the dynamic in the courtroom. She wasn't just defending the administration, she was challenging Alsup to justify his position on legal grounds, not emotional ones. Her citation of Supreme Court precedents was a reminder of her deep legal knowledge, a fact Alsup couldn't ignore. She had also planted a seed of doubt, hinting at an appeal that could take the case out of Alsup's hands and into a higher court, where the conservative majority might side with the administration. Alsup paused, his expression a mix of surprise and irritation. He hadn't expected Bondi to push back so forcefully, nor had he anticipated her readiness to escalate the fight. For a moment, the judge seemed at a loss for words, a rare occurrence for a man known for his quick wit and sharp tongue. Bondi's composure under pressure was striking. She wasn't just holding her ground, she was turning the tables on a judge who had underestimated her. Mr. Helland, the plaintiff's attorney, seized the moment to interject. "Your Honor," he said, his voice urgent, "the Attorney General's argument ignores the evidence. We've presented internal OPM memos and emails showing that the White House directly ordered these firings. The January 20th memo explicitly instructed agencies to terminate all probationary employees not deemed mission critical, and the February 14th email set a deadline for compliance. This wasn't guidance, it was a directive, and it violated federal law. The RIF process exists for a reason, to protect workers and ensure fairness. The administration can't just fire thousands of people without following the rules. Helen's words were a reminder of the human cost of the firings. Thousands of workers, many of them veterans, had lost their jobs overnight with no notice or opportunity to appeal. The plaintiff's case rested on the argument that the White House had overstepped its authority, using the OPM as a tool to carry out a politically motivated purge. Helen hoped his evidence would sway Alsup, who had already shown sympathy for the plaintiff's position. But Bondi was ready with a counter-argument. "Your Honor," she said, addressing Alsup directly, "the plaintiffs are cherry-picking documents to fit their narrative. The January 20th memo and February 14th email were part of a broader policy discussion, not a binding order. Agencies were given discretion to assess their staffing needs, and they acted within their legal authority. The Civil Service Reform Act allows for the termination of probationary employees without the full RIF process, as long as basic due process is followed, notice and an opportunity to respond, which these employees received. The plaintiff's claim of a purge is speculative and unsupported by the law." Alsup wasn't convinced. "You keep talking about discretion, but the evidence tells a different story," he said, his voice still sharp but less heated than before. The timing of these firings, thousands of employees let go on the same day, across multiple agencies, suggests coordination, not discretion. And the RIF process isn't optional when you're dealing with mass terminations. The law requires notifications, especially for veterans who have specific protections. You can't just wave that away with a memo. Bondi nodded, acknowledging Alsup's point without conceding ground. "Your Honor, the administration understands the importance of veterans' protections, which is why agencies were instructed to prioritize retaining veterans where possible. But the law doesn't require a full RIF process for probationary employees, even in large numbers. The RIF process applies to career employees with tenure, not those still in their trial period. The plaintiffs are conflating two different legal standards to create a sense of injustice where none exists." Alsup leaned back, his expression skeptical but less confrontational. Bondi's argument was legally sound, even if he didn't agree with the administration's actions. Her ability to pivot from Alsup's emotional accusations to a reasoned legal defense was impressive, and it forced the judge to engage on her terms. For the first time in the hearing, Alsup seemed to realize that Bondi was not an opponent he could easily dismiss. Helen tried to regain momentum. "Your Honor, the Attorney General's interpretation of the law is too narrow," he argued. "The Civil Service Reform Act may allow for probationary terminations, but it doesn't permit the White House to orchestrate a mass firing through the OPM, which lacks the authority to issue such directives. The OPM's role is to set personnel policies, not to order terminations. And the scale of these firings, thousands of workers across dozens of agencies, demands a formal process, regardless of their probationary status. The administration is trying to rewrite the rules to avoid accountability." Bondi was quick to respond. "Your Honor, the OPM's authority comes from its mandate to manage the federal workforce, as delegated by the President under Article 2 of the Constitution," she said. "The Supreme Court has upheld the executive branch's broad discretion in personnel matters, as seen in Myers v. United States. The President has the right to ensure that agencies are staffed with employees who support his policy goals. That's not a purge, it's governance. The plaintiffs are asking this court to micromanage the executive branch, which is beyond its jurisdiction." Alsup's eyes narrowed, but he didn't interrupt. Bondi's argument was a direct challenge to his authority, suggesting that the court had no business interfering in the President's management of the federal workforce. It was a bold move, one that could backfire if Alsup felt his judicial role was being undermined. But Bondi wasn't done. She pressed her advantage, her voice steady and confident. "And let's be clear, Your Honor," Bondi continued. "The plaintiff's real complaint isn't about the law, it's about politics. They disagree with the president's agenda to streamline the federal government, an agenda he campaigned on and won. The American people elected President Trump to drain the swamp, and that includes ensuring our agencies are efficient and aligned with his vision. The plaintiffs are using this court to obstruct that mandate, and I respectfully submit that this case should be dismissed for lack of merit." Alsup's expression hardened, but he didn't lash out. Bondi's argument had shifted the focus from the legality of the firings to the broader question of executive authority, a topic that played to the administration's strengths, especially with a conservative Supreme Court waiting in the wings. Alsup knew that if he ruled against the administration, Bondi would appeal, and the Ninth Circuit, or the Supreme Court, might overturn his decision. For a judge who prided himself on his legal rigor, the prospect of being reversed was a bitter pill to swallow. Helen sensed the shift in the courtroom's dynamic and tried to refocus the argument. "Your Honor, this isn't about politics. It's about fairness," he said, his voice passionate. "These workers were given no notice, no chance to appeal, no opportunity to find other roles. Many of them are veterans who served our country, only to be discarded by their own government. The administration can't hide behind executive authority to justify breaking the law. We're asking for an injunction to stop these firings and hold the White House accountable." Alsup nodded, his sympathy for the plaintiffs evident. But Bondi's legal arguments had given him pause. He couldn't dismiss her points out of hand, not without risking a higher court's rebuke. The judge took a moment to gather his thoughts, then spoke, his tone more measured than before. "I'm not convinced by the administration's argument that these firings were discretionary," Alsup said. "The evidence suggests a coordinated effort, directed by the White House, and that raises serious questions about the OPM's authority and the lack of a formal RIF process. However, the Attorney General has raised valid points about the executive branch's discretion and the legal status of probationary employees. I'll take this under advisement, but for now, I'm issuing a temporary injunction to halt further firings and rescind the OPM's memos. We'll schedule another hearing for April to hear from the OPM's acting director, Charles Ezell, and get to the bottom of this." Alsup's ruling was a partial victory for the plaintiffs, but it was clear that Bondi's performance had influenced his tone. Gone was the fiery outrage he had directed at her earlier. Now he was focused on the legal merits of the case, a shift that reflected Bondi's ability to steer the debate onto her terms. The judge had learned a lesson. Underestimating Pam Bondi was a mistake, one he wouldn't make again. As the hearing adjourned, Bondi gathered her papers and prepared to leave. But she had one more move to make, one that would ensure the administration's narrative dominated the headlines. She stepped outside the courthouse, where a crowd of reporters and cameras awaited. Standing in front of the microphones, Bondi delivered a statement that would reverberate across the nation. The American people elected President Trump to drain the swamp, and that includes ensuring our federal workforce serves the public, not entrenched bureaucrats, Bondi said, her voice carrying the same confidence she had shown in the courtroom. "We respect the court's process, but we believe the law is on our side. We'll continue to fight for the president's vision, in this court and beyond, because the American people deserve a government that works for them. We'll take this to the Ninth Circuit, and if necessary, to the Supreme Court. We're not backing down." Bondi's statement was a masterstroke of political strategy, turning a legal setback into a rallying cry for Trump's base. She had taken Alsup's criticism, a sham that had made him mad, and used it to fuel a broader narrative of fighting against the establishment. The media frenzy that followed ensured that the administration's message reached millions, overshadowing the court's injunction and framing Bondi as a fearless defender of Trump's agenda. Inside the courtroom, spectators were left in awe of Bondi's performance. They had expected her to crumble under Alsup's attack, but instead, she had turned the tables, forcing the judge to engage on her terms and laying the groundwork for a legal battle that could reshape the balance of power between the executive branch and the judiciary. Bondi's legal acumen, honed over years as a prosecutor and state attorney general, had been on full display, and it was clear that she was more than a political appointee. She was a formidable opponent, one who had taught Alsup a lesson in humility. The plaintiffs, led by Mr. Helland, were disappointed but determined to press their case at the next hearing. They knew they had won a temporary victory, but Bondi's performance had raised the stakes. The administration was prepared to fight, and with Bondi at the helm of the DOJ, the battle was far from over. For the fired workers watching from the sidelines, the hearing was a roller coaster of emotions. They had hoped for a clear win, a chance to reclaim their jobs and hold the administration accountable. But Bondi's arguments had cast doubt on their case, and her appeal to higher courts meant their fight was just beginning. Still, they couldn't help but admire her tenacity, even if it was directed against them. She had walked into a hostile courtroom, faced down a furious judge, and emerged with her head held high, a testament to her skill and determination. As Bondi left the courthouse, her mind was already on the next steps. She knew the Ninth Circuit would be a tougher battle, but she was confident in her legal strategy. More importantly, she had sent a message to the judiciary and the public. The Trump administration would not back down, and she was the right person to lead the charge. Alsup had mocked her, calling her case a sham, but Bondi had turned his words into a badge of honor, a rallying cry for a fight she was determined to win. The mass firings lawsuit was far from over, but one thing was clear. Pam Bondi had shocked everyone with her handling of the case, teaching Judge Alsup a lesson he wouldn't soon forget. Her blend of legal precision, strategic defiance, and political savvy had turned a courtroom clash into a national spectacle, one that would define her tenure as Attorney General and cement her place in the Trump administration's legacy.